Folks, we're just waiting on the senator. We'll get started here in just a few minutes, so thanks for your patience as we wait. Thank you.
All right, come on in, everyone. Catch your seat. Thank you so much for being here with us today. We're so glad to have you. I'm Jason Perry with the Hinckley Institute of Politics, and we are so glad this is day number 2, Senator, for our students here on campus. You can tell because there's no parking. You all notice that? So we love having those students here. Day number 2, and we will have had within 2 days both of our senators, and we are so lucky to have Senator Mike Lee here with us today. He's been a good friend of the Hinckley Institute, and we're glad to have you here with us today. For those of you who we'd love to have you stay after we hear from the good senator. We'll have a panel discussion here to talk about some of the issues that will have been discussed. And as always, we have Rick Larson, our partnership with the Sutherland Institute. We are so grateful for to have you here today to have this critical conversation with our great senator here. Senator Mike Lee, thank you for being with us.
Thank you.
Let's give a hand for Senator Mike Lee.
I'm going to state 2 things. I'll be checking my watch, not because I have other things to do, but we want to get you out of here on time. And I want to give you a few minutes before we get into some Q&A to set the table a little bit about what we're going to talk about today.
Fantastic. We're going to talk today about one of my favorite topics. It deals with the delegation of lawmaking power. Over the last 80 years, Congress, and by Congress I mean broadly, Houses of Representatives, Senates, and White Houses of every conceivable partisan combination, have gradually been delegating out the lawmaking power that the Constitution gives to one branch, to the Congress of the United States. When our founding fathers put together our system of government, they made Congress the most dangerous branch. And we know that for a number of reasons, not just because of their commentary, but because of what they put into the Constitution. They knew that the power to make law is inherently dangerous and therefore made Congress the branch of government most accountable to the people at the most regular intervals. Every member of the House is up for re-election every 2 years. 1/3 of the members of the Senate are up for re-election every 2 years. And this is because the power to make law can be used abusively, and they always wanted to make sure it was close to the people. Generally speaking, this was followed. The very first operative provision of the Constitution, the first clause of the first section of the first article, Article 1, Section 1, Clause 1, says all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. Article 1, Section 7 then makes the point clearly by saying if you want to make a federal law, you must follow the Article 1, Section 7 formula, which is you have to have Congress act by the House of Representatives and the Senate enacting the same language, presenting it to the President for signature, veto, or acquiescence. Over the last 80 years or so, Congress has gotten by. Again, it's a problem of bipartisan creation with passing what sometimes amount to platitudes, broad aspirational statements, and then delegating the lawmaking power over to an executive branch department or agency. It often reads something like, we shall have good law in area X, and we hereby delegate to commission, department, or agency Y the power to promulgate rules that then have the force of generally applicable federal law. This is an interesting phenomenon that can be observed graphically. I keep 2 stacks of documents in my office in Washington, one short stack and one tall stack. The short stack is usually a few hundred to a few thousand pages long for a particular year, and it consists of the laws passed by Congress in the last year. The other stack is often 13 feet tall, can be as long as 100,000 pages, and it consists of last year's Federal Register. For those of you who are fortunate enough not to know what the Federal Register is, it's the annual cumulative index of federal regulations as they're promulgated by executive branch agencies. Promulgated meaning released to the public initially for notice and comment, saying, these are the laws that are about to govern you, let us know what you think. And then they circulate them again after they've been finalized following the notice and comment process. 100,000 pages. The American people are bound in countless instances by what's in those 100,000 pages. But the difference is the people who write those 100,000 pages don't work for you. You don't ever get a chance to vote for or against them. And that's a problem that I want to talk about today.
Fantastic. I love the grounding in the Constitution. I want to start there because I've been looking at some analysis of the REINS Act. We're going to talk specifically about that piece of legislation because I think there's a a directional signal within that that's important. So when most people criticize Congress today, they say it's dysfunctional and they've abdicated their authority to the executive branch. Everything's done by executive order. Congress isn't functioning. Tell me, describe the REINS Act in that context, because I see a move towards accountability.
Yes. The REINS Act is a legislative proposal that aims to address the very problem that I've just described. It's a bill, and it stands for Regulations from the Executive in Need of Scrutiny. And what it says, in essence, is that for every new major rule regulation, that is, a regulation that imposes affirmative legal obligations on the public, not to be confused with an internal regulation determining, let's say, what time the lights go on and off in the State Department or the Department of Commerce, and that is deemed economically significant by the Office of Management and Budget, would not be self-executing. It couldn't take effect without Congress affirmatively enacting it into law. In other words, it's a means by which new major rule federal regulations would be treated as legislative proposals to be considered on a fast-track basis by Congress. It couldn't take effect without being enacted affirmatively into law. The REINS Act isn't a complete cure. It's not a complete fix to the excessive delegation of lawmaking power, but it is as close, as nearly perfect a fix as I have found, and I think would fix the overwhelming share of the problem. And what we're trying to fix, again, is the detachment from the American people of the authority to make law. James Madison, as if anticipating our day or fearing that we might see something like this, commented in ways that were eerily prescient at the time, in the late 1700s. In Federalist 62, he said words to the effect, of paraphrasing slightly, words to the effect that it'll be of little avail to the American people that their laws are written by men and women of their own choosing, if those laws be so voluminous, complex, and ever-changing that they can't be read and understood by those subject to them. Because a law is a rule of action. You can't know what you're expected to do or not do unless there's some mechanism by which you can know that. So this is about accountability, and it's about liberty in the purest sense. What it means to live in a free country, what it means to live in a system in which your government operates pursuant to democratic principles means that those who make your laws should be elected and accountable through an election.
Let's put it in context for those who have not affected their minds by a deep dive into political science, as some of us have. We all remember, at least some of a certain age, we remember the great little television ditty about how a bill becomes law. Some of us can still hum the tune. But let's talk a little bit about legislative intent and why this is so important. And for a context, so versions of the REINS Act, as far as I could tell, have been thrown around since 2009, 2010, and it's finally progressed to this point. We have legislation on the books that has to do with things like immigration, the environment. Let's talk about legislative intent years and years ago and what happens administratively now to what on its face seems a really good law before it goes into this administrative cycle.
Yeah. So when I look at legislative intent, I should clarify the caveat. I believe what matters is not the subjective intention of any one lawmaker or group of lawmakers so much as the public meaning of the words they use at the time the legislation is enacted. It can be difficult to ascertain, and people can disagree as to what the original public meaning is or was at the time of the enactment of any law. But we do have tools by which we can measure these things and achieve some rough approximation of what was intended. One of the problems with excessive delegation of lawmaking power, and one of the reasons why we need the REINS Act, is that when you strip the meaning from the originating legislation in the first place, there's nothing there. It's an empty vessel. And so as an executive branch agency tries to breathe life into something by promulgating regulations that they deem consistent with the stated purpose and effect of the originating legislation, if all it says is we shall have good law in area X and agency Y has the power to make rules carrying the force of generally applicable federal law, there's nothing there. It's like when you're a kid and well, it's not exactly like this, but bear with me. You go to your mom and you ask for permission to go to your friend's house. And your mom says, go ask your dad. You ask your dad the same question. Your dad sends you back to your mom. There's a choice of law, conflict of laws term for this that we use that you'll learn when you go to law school if you choose that path, called the renvoi. It's a law French term. It means to return unopened. And so the law is now full of renvois insofar as the executive branch agency folk, the people who are drafting these regulations, they don't really have a lot to go on, and so they just make it up as best they can. And I want to be clear, these executive branch bureaucrats, I don't want to send the impression that I'm referring to them derisively as a whole. These are, by and large, people who are well-intentioned, hardworking, highly specialized in their fields, and are doing the best job that they can. I don't actually blame them. I strongly dislike a lot of the policies they come up with. But they're not actually the problem. We are. Congress is the problem because we gave them this unbridled authority to begin with. And it manifests itself in countless ways that are difficult to anticipate. A few years ago, one of my roles in the Senate, I serve on the Judiciary Committee. And we have jurisdiction over, among other things, the Federal Criminal Code and sentencing laws. I was involved in a long-time effort to reform our sentencing system and a very large criminal justice reform package we got passed a few years ago. Sort of in tandem with that, we were wanting to know the answer one day to the following question. How many federal criminal laws are there? How many different federal criminal offenses exist? We asked the question of the Congressional Research Service. CRS is an agency whose job it is to answer questions like that by people in Congress so that they can know how best to address our lawmaking needs. The answer that came back was stunning. They said that the answer is both unknown and completely unknowable, but that there are at least 300,000 federal criminal offenses on the books. And their explanation was revealing as to why it's unknown and unknowable, but at least 300,000. They said a lot of these crimes are made not by statute, but by federal regulation issued by an executive branch agency promulgating these rules. And so when you live in an era, going back to James Madison's language, where the laws, in addition to being so voluminous, complex, and ever-changing, you can't know what they are. They're not even made by men and women of your own choosing. That's messy. And it's why I'm so passionate about the REINS Act. We need to reform this.
So there are a couple of thresholds within the REINS Act. One is that this oversight is triggered by certain budget amounts. If a decision takes expenditures over, I think it's $100 million.
Compliance costs.
Compliance costs. One is if it becomes an imposition on business, those types of things. A couple of them fascinate me. One is the call for the review of at least 20% of agency rules currently in effect. I'm wondering how that will be prioritized. Referencing the stack on your desk, the larger one, a little research showed that federal agencies have finalized over 3,500 regulations per year in each of the last 3 years. So with that depth of regulatory action, where do you begin in your review of the 20%?
It's a difficult task. It's hard to know where to begin. I believe that gives discretion to the Director of the Office of Management and Budget to know where to begin that review. I'm not sure where they would start it. It would probably depend on who was the OMB director at the time and what he or she deemed the greatest priorities. There have been other versions of the REINS Act that have been introduced in the past and others that will be introduced over the next year or two. One version that I had introduced in the past had what I called a filter in it, one that would require all existing executive branch promulgated regulations carrying the force of generally applicable federal law to sunset after it was either a 5 or a 10-year period so that you could filter everything back through. As a practical matter, whether you have that in there or not, almost everything is eventually going to make it through the cycle because over time, regulations change and that triggers a process and you have to issue a new regulation to change an old one. I still will feel better once we get this version replaced with something that has some kind of a mandated filter.
Do you see a risk? It seems in the environment we live in today, virtually everything is politicized, even if it need not be. Things that we could easily consider and say what is best for humankind. Do you see a risk that certain more controversial and dated law, for instance, those issued by the EPA, could those become a stumbling block and a point where it locks up again and the review can't be completed?
In a nutshell, yes, but that's the whole point. When we use the word politics, we use it derisively and understandably. As some might say, to understand the word politics, you have to break it down into its Greek roots. Poly, which means many, and ticks, which are blood-sucking parasites. You put them together, and it's not a pretty picture. So yeah, it will inject politics into this, and some of those could be controversial. That is the whole point. The Constitution itself is a political document, a democratic system of government founded on a constitutional republic like ours cannot operate without a political system. In fact, that's what differentiates government of, by, and for the people from a tyrannical regime, is a political process in which voters have input, at least on those who are making the law. And so yes, some of that will be a stumbling block, and that is precisely the point, because the way this operates, very often a new major rule, regulation will come out, and it may have devastating consequences for an entire industry, for an entire region, for a particular state, or a particular part of one state. And again, this isn't because of people who run these agencies are bad or dumb or malicious, so much as it is that they've got a limited view and they can't see everything all at once, and they're sometimes going to get things wrong, or they're not always going to see everything. We've had circumstances, for example, where the EPA has placed limits in certain parts of the country, including parts of our state, limits for ozone at levels below where Mother Nature herself has set them, making it impossible to achieve certain types of permits in those regions. People get upset when that happens. That's the tip of the iceberg, but it's one example of just showing where they might get it wrong. But those are exactly the kinds of things that do need to be subjected to the light of day and public debate so that those things can be aired.
In keeping with your support for this and the potential of greater transparency and oversight and function of Congress, Cato, a national think tank, in a summary report on this said the primary effect of the legislation would be to make Congress more responsible for federal regulatory activity by forcing legislators, I think this is interesting, forcing legislators to voice their opinion on the desirability of significant regulatory changes. In other words, they can't hide behind a president or a public opinion poll. That's a good thing.
It's a very good thing. In fact, it's a necessary thing. It's absolutely essential to the way our system of government is supposed to operate. Very often when one of these regs comes out, and every once in a while they come out with a real doozy that really harms a lot of people. A new regulation will always have some fans, but it may have a lot of enemies as well, and a lot of people who are harmed by it will understandably, properly go to their members of Congress, their senators and their representatives, saying, please help us with this. Members of Congress are notorious in those moments for beating their chest and pounding the table and saying, doggone it, which is strong language where I come from. You know what I'm going to do in response to this? I'm going to write a harshly worded letter to that agency, and I will show them a thing or two. I wrote a book in which I talked about some of this, chapters 3 and 8 of a book called Our Lost Constitution I wrote a few years ago. Talked about some circumstances in which members of Congress who had voted for one of the iterations of the Clean Air Act before it resulted in regulations that proved controversial in the New York metropolitan area. Some of the same members of Congress who had voted for the legislation, campaigned aggressively on it, came out and openly protested against the EPA for promulgating regulations that they themselves had just authorized the EPA to promulgate. Again, not EPA's fault, it was their fault, they did it. The point here is to require them to make the law. Again, that is why the founders put this only in Congress, because Congress is the branch of government most accountable to the people at the most regular intervals, and that's necessary because we wield the most dangerous power in the federal government.
It's interesting, as I read some of the key points of the legislation, there was one inclusion that I'm going to guess wouldn't have been there in 2010. And I debated whether or not to bring this up, but I suspect that the roots of this are both constitutional and possibly commerce issues, that it calls for oversight of any increase in mandatory vaccinations. And I bring it up because morning news, anyone who heard it, Rutgers University is again imposing all kinds of regulations on campus, distancing, masks, vaccination to live in student housing. Tell me a little bit about how that specific point made it into the sequence of this legislation.
That provision made it in before I arrived in Congress. The short answer to your question is I have no idea. I will find that out.
It's a good answer. Yeah, it's a good answer. Transparency seems to be a theme for you. If I can shift just a little bit, in July you introduced the HERO Act, Higher Education Reform and Opportunity Act, and I thought it fitting as we're sitting here on a campus to talk a little bit about your objectives for bringing transparency to higher education.
Yeah. One of the things that we want to do, the Higher Education Reform Opportunity Act accomplishes a number of things. Among other things, we want to make sure that our higher education system in the United States is the best that it can be, and that we don't have, we're not holding it back in a bygone era. We have long assumed that to provide a quality higher education, you have to be stuck in the Carnegie unit, in the 50-minute hour and the credit hour system that everybody has learned. But there is a lot that I think can be achieved in the higher education space through things like mentorship programs, apprenticeships, massive open online courses or MOOCs. And yet all those things are taken outside the umbrella of eligibility for participation in federal higher education assistance. We think it can benefit from this. So that, coupled with mandatory reporting requirements on what people are graduating in, or what their employment situation looks like years after the fact, the ability to repay any loans they've taken out, it's sort of consistent with the truth in lending standards. As long as the federal government's going to be making itself the lender in this area, it ought to provide some transparency to the borrower so that they know what they're getting.
So this may just go in purely into personal opinion, but I'm interested in that. Again, because we're on campus, some of the negative attacks on higher education, they wander all over the place, from the student debt crisis to the value of certain degrees, workforce issues, participation in workforce issues. There are all kinds of layers to this. And then enter artificial intelligence. Would you say to a young audience, what is the value of a higher education? Is it more important we know how to run a certain software, or should we still invest our time in a complete education, and what value does that hold to society?
Look, as the son of a former university president, I strongly believe, in part because it was drilled into me from the time I could crawl, that there is independent value to obtaining an education. Even including and especially an education outside the field in which you might earn a living. That's why there is a lot of importance to a liberal arts education, or at least a component of general education requirements that make sure that you get some breadth of an educational background. A lot of things in life that you might not do for a living, but that are nonetheless going to inform and enrich everything else you do. So I think there is and always will be a place for a traditional higher education learning environment. It's just that shouldn't be the exclusive eligible recipient of federal higher education assistance.
So I always feel compelled to state, for those who may not be familiar with Sutherland Institute, that we are a nonpartisan public policy think tank. So no questions are motivated by a political agenda. However, we're coming up on a very interesting election. I'd love your thoughts. You've been in the Senate for some time now. What have you seen evolving? How is the function of Congress, in your view, compared to when you first entered? With all you've learned, all you've seen, a number of things you've accomplished, where do you think it stands today in terms of functionality? And do you have concerns as you look at the election landscape in 2024?
Oh, I've always got concerns. Look, one of the beauties of our system is that nothing is a sure thing in our system of government. That's good for everyone, I think. The fact that nothing is assured means that the people are in charge, and the people can change their minds, and they frequently do change their minds based on evolving conditions on the ground. As far as the condition of Congress and what I've seen in the way it's changed in the 12 years or so since I first came to the Senate, there are a couple of trends that I find disturbing, and these are these cross-party lines, so it's consistent with your nonpartisan theme. In both houses of Congress and in both political parties, as their members are reflected in both houses of Congress, I've seen a trend toward a consolidation of power. We've seen this generally in the federal government over the last 80 years. It's part of the phenomenon I described a moment ago. Over time, you have tended, since the New Deal era, you've tended to see people, transfer of power going from the American people in two steps. First, from the people at the state and local level being transferred to Washington. Then within Washington, you've seen a lot of power transferred from the people's elected lawmakers over to unelected, unaccountable bureaucrats who end up wielding a lot of the lawmaking power. But even within Congress, even where we are still doing our job as lawmakers and still passing laws, there is a different type of excessive consolidation of power that I also find troubling, which is that members are tending more and more to defer to and behave as if they worked for the legislative party leaders in their respective houses of Congress. I'm referring, of course, broadly to what I sometimes describe as the law firm of Schumer, McConnell, McCarthy, and Jeffries. And over time, I've seen more senators and more representatives behave as if they worked for the Republican or the Democrat in the House or the Senate, depending on which house they serve in and which party they belong to. I find that troubling because, look, parties don't agree on everything, and it doesn't reflect, in my view, it usually doesn't reflect a petulant desire to be disagreeable between the two parties. They reflect sincere disagreements among those who elected them. But there are areas where the parties are not necessarily dead set against each other. There is a lot of nuance in the law. There are a number of areas that are not necessarily staked out as either Republican or Democratic territory, and there's a lot of bleed through. There are countless examples of this. There is an emerging war-leery segment of my own political party, and I'm part of that. I'm something of a, I don't know whether to call myself dovish, but I am not a war hawk, which makes me somewhat anomalous as a Republican. One of countless examples of where there's not a perfect mirror image, reverse symmetry between the two parties. And it's good for members to be able to explore those areas on their own to figure out what the best policy solutions are and where there are areas for potential agreement. What often thwarts that is when they start to defer to their respective party legislative leader in their respective chamber. That results in a sort of outsourced thinking. Mitch McConnell is my colleague from Kentucky. I don't work for the senator from Kentucky. I work for the people of Utah.
It's an important point, especially I think there's great value in having these conversations in a campus environment, because there has been a trend of late where these open conversations somehow are not invited in a campus environment. We've never found that to be the case in Utah, but I've certainly read about the national trends. So as we sit here with students among us, what is your outlook? The founders warned against the potential dysfunction of party politics. What is your message to a young voter when things get a little out of whack? Do we scrap the system and look at other nations and say they're doing it better than us? What is the correct response?
Well, first of all, if we were to go that direction, I would want to know what other nations are doing it better than us. Because in most circumstances, you either look at that nation's system of government and you discover that it's not quite as green on that side of the fence as you thought before the inspection, or alternatively, yes, that works for them there, but there are a number of reasons why that won't work here. I'm never one who's inclined to scrap our system of government, because I think the system works well as far as we follow it and we respect each other in doing so. It is being tried. I think it's being stretched in part because we have neglected its structure. When we think about constitutional protections, the first thing that comes to most of our minds If you were awakened in a dead sleep and somebody said, what are constitutional rights? For most of us, the first thing that would pop out would likely be a reference to, I don't know, the First Amendment, freedom of speech and religion and so forth, or, Fifth Amendment privilege against self-incrimination, Sixth Amendment right to a jury trial, Fourth Amendment protection against unreasonable searches and seizures, or something like that, one of the thou shalt nots of the Constitution. Those are all important, and they're part of the Constitution. We need them. But they are not the only thing in the Constitution. What we're neglecting are the structural protections of the Constitution. I think those have been the most overlooked, and they're also the most consequential to overlook. Because everything else, all of the thou shalt nots in the Bill of Rights, for example, they function well only to the extent that we have in place structural protections to protect us against the dangerous accumulation of power in the hands of the few. Justice Scalia and Justice Breyer used to go around and do this sort of roadshow where they would talk about the law and they would kind of make fun of each other's style of constitutional and statutory interpretation. It was fantastic. But in some of these sessions, they would say, Justice Scalia in particular would say, any tin-horn dictator anywhere in the world can have a Bill of Rights. And in fact, most tyrannical regimes throughout the world do have bills of rights. Many of them resemble our own. Some of them even put ours to shame in terms of the breadth of the scope of protections that they provide. But he said, what differentiates one from another and what makes the difference between a place where liberty thrives and where tyranny prevails is whether you've got these structural protections to protect against the dangerous accumulation of power in the hands of the few. So look, our system is being stretched, sometimes almost to the breaking point, because of the way we've neglected the structural protections. We've assumed that everything is federal when it is not. And thus, we've forced an expectation that's unrealistic. Has been since the founding of our country. We think, I mean, we are very diverse today, but we think we're unique in our diversity today. Founders lived in a diverse republic as well. The original 13 states had a lot of differences between them, culturally and otherwise, economically, in so many different ways, came from different backgrounds and different belief systems. So they understood then that we wouldn't be able to agree on everything nationally, and that's why it was important to keep most powers of government close to the people at the state and local level. And the reason is you allow more people to have access to more of the kind of government that people want and less of the kind of government they don't want. And that's why they limited the power they gave us at the federal level to national defense, weights and measures, trademarks, copyrights and patents, bankruptcy laws, regulating trade or commerce between the states, foreign nations, and with the Indian tribes, granting letters of marque and reprisal and declaring war. There are a few others, but that's basically it. So we've neglected that one, inverting the pyramid. Madison described the powers of the federal government as few and defined, and those reserved to the states as numerous and indefinite. We've inverted the pyramid over the last 80 years or so. It all started on April 12, 1937, when the Supreme Court decided a case called NLRB versus Jones and Laughlin Steel. I want to come back another day and talk about that case because they changed the Constitution. That reversed the trend. And then once we brought that much power that belonged with the people at the state and local level to Washington, members of Congress choked on it. And they said, oh my gosh, we're going to be accountable all of a sudden on all these local activities. Labor, manufacturing, agriculture, mining, health, safety, welfare. They're all under our purview now. So what do? And that's why they delegated the power to executive branch agencies. So we messed up both of the twin structural protections. Federalism being vertical, separation of powers being horizontal. We distorted both of them, starting in the New Deal era, and we have been deviating further from them ever since then. My point is this, in response to your question. The system appears to be struggling because we have completely disregarded those core protections that are upstream from everything else. I think if we restore those, we'll find that it's going to function quite well. And that even the richness and the depth of our disputes as a country, they won't go away because people still disagree. People see things differently. It's just human nature. It's always going to be that case as long as we live on the earth. But we can manage it a lot better if we don't demand absolute consensus where consensus is impossible.
I want to touch on that inversion maybe as a closing statement, but one more question before we get to that. It's a great deal of conversation today about civility, about finding ways to have conversations minus this contempt for one another. So I think you would have a valuable answer, because there are times when you will vote in a way that the press will grab and say, oh, he's going counter to the party, whether it's a budget ceiling or whatever it is, he's being difficult. Where is your anchor, and how does one disagree civilly without abandoning their principles?
It's a lot easier to disagree civilly if you focus on the principle rather than on the personality involved. It makes it easier not to personalize something. It's easy to get upset if you feel like somebody is attacking you personally by proposing a bad policy or a bad law. If you're focused instead on the people you're responsible for looking out for, and the fact that you took an oath to a constitution that requires certain procedures to be followed and that limits the scope of your authority to begin with, that takes down the temperature a lot. And I should add here, you know, if I believed everything I read in the paper and everything I knew about Congress were limited to what I read in the paper or see on TV or on social media, I would probably believe that Congress was a far more barbaric, hostile, and openly contemptuous place than it actually is. Just imagine for a minute, whether you're a student or a professor or you do something else, imagine if you operated in a world in which there were reporters, TV cameras present, following you throughout your workday or your school day or whatever, and they segmented out sort of the spiciest moments of your interaction or your classmates' interaction with anybody else, and then aired those. People would probably have an impression that your life was full of a lot more contention than it actually is. It's the nature of things. If it bleeds, it leads. If there are people yelling at each other, that makes for much more compelling reporting than if it's not. There's actually a lot more civility in Congress than I think meets the eye. It's gotten a little tougher of late because emotions sometimes get away with folks, and I do believe that will continue to get worse as long as we continue to put more and more into the federal government that may not necessarily belong there. It's only going to get more contentious. But it's not nearly as bad as it appears. Speaking only for myself here, a lot of my favorite people are people who I disagree with on most votes within the Senate. Some of my favorite colleagues are people who I have to struggle a little bit more to find areas where we agree. There's a great picture of me and Bernie Sanders hugging in the Washington Post a few months ago, working on a war powers issue. Those sorts of things happen, and I can't think of a single Democratic colleague I have who I don't really like.
That's important. Thank you for that. So let's wrap up with this. And I ask this a little bit selfishly because I've heard you answer similar questions before, and I think it'd be valuable to the audience. So the government is the largest employer in the nation. There's been an inversion. The media does not help with the perception of civility and cooperation. There are a number of things wrong. Where do we begin to turn it back to its proper structure? Is there hope? Can we turn it back? And where do we begin as individuals?
It can be turned back because this is a government that's in the hands of its people. As George Washington was preparing to leave the presidency at the end of his second term, you know, he's full of all these thoughts and emotions, and he talked about going on this walk through the city of Philadelphia, and he was worried about the country. You know, it was still a new country. We're still a new country. I hope we'll always be a new country. He didn't know where things were going, and he said, I had this realization: the American system of government is in good hands because it's in the hands of the American people. And so it's one of the reasons why I focus so much on reforms like the REINS Act, because they help realize the promise of keeping the American people in charge of their own government. So literally every 2 years, not just every 4, but every 2 years, the American people have the ability to almost completely remake federal policy. The fact that they don't always make significant shifts from one 2-year period to another doesn't mean that they can't. It just means that they haven't yet. But I do think there is a real opportunity, and it's an opportunity that I hope, that I fundamentally believe exists in both political parties. Federalism and separation of powers at their core are neither Republican nor Democratic. They're neither liberal nor conservative. They are simply constitutional principles. They are process principles and structural principles. I very much look forward to the day when in both political parties it will be seen as not only acceptable but expected and desirable for candidates to openly campaign on areas in which they would, if elected, make themselves and the office to which they're aspiring less powerful. Because I think most of us can agree that there is too much power in Washington. This is what causes so much emotion around it. This is what causes protests and people behaving in crazy ways every time there's a presidential election, often when there is just a congressional election, is there is too much there. Let's take the temperature down. So yes, they can do it. Ultimately, they will do it. The sooner the American people make that choice, the better off we're going to be.
Thank you. Could we give Senator Lee a hand? And I want to thank all of you for attending, for being here today. I would ask, we want to keep the senator on time. As much as we'd all like a selfie, we're going to ask you all to remain seated as we escort him out the side door so he can get on to other important things. But thank you very much for your time, for being here, and thank you, Senator.
Thanks so much.
Thank all of you for being here, and thanks again to the Senator and to Rick for that excellent conversation. We'll now transition to the policy panel portion of the Sutherland Congressional Series. So I'd like to invite our panelists to come up and join me up front. We'll have Bill, you right here in the middle. So as we get situated, I'll introduce our panelists. To my right is Bill Duncan. He is the Religious Freedom Policy Fellow here at Sutherland Institute, and also kind of our resident expert on all things to do with the law, the judicial branch, the Constitution. And we're also joined by Michael Diccio, who's a professor here at the university teaching political science, with a lot of great expertise in some of the areas that we heard about from the senator and some things we'll be discussing today for our panel portion. I want to start off by mentioning something that Senator Lee talked about there towards the end, and this idea of federalism and the separation of powers. And he actually used the term vertical and horizontal. And I want to start off by asking both of you, if you had to describe the system to somebody who wasn't familiar with it, in very simple, brief terms, the system of federalism, what is it, our system of separation of powers, and keeping in mind that concept of there's horizontal, there's the different branches of government, and then vertical. We have the national level, the state level, the local level. So Bill, let's start with you, and then go to you, Michael. How would you articulate the system, and maybe also add, here's how it should work if it's working at its best?
I was hoping that Professor Diccio would go first, actually, but yeah. But having said that, well, I think my way of thinking about this is that the Constitution, as Senator Lee pointed out, has a lot of structural provisions. And if you think about the Constitution as a document, I've always made the same observation as he has, that when people think about Constitution or constitutional law, they think about the amendments. But the Constitution enacted, or at least approved in 1787, had a lot more to do with sort of apportioning out certain powers between different branches of government. And the understanding of having a written constitution is a suggestion that the things that are specifically guaranteed, although some of those are pretty broad, but the specific powers are going to be given to different branches, and those are to be pretty exclusive, right? So that if the Constitution says that Congress has the power to do these things, Congress doesn't have the power to do things that are not mentioned there, and down the line. Now, of course, over time we're going to see that barriers are somewhat permeable, but theoretically they should be. And then between the states and the federal government, well, the notion of a federal government created by the Constitution was that the federal government would have certain powers and then everything else, and this is specifically mentioned, of course, in an amendment to the Constitution, would be left for other levels of government at the state and local, and even, depending on how you read the Ninth Amendment, maybe even some things that no government is able to do at all. I don't know if that's responsive. You probably have a better answer or thought about that.
I thought that was wonderful, Bill. Just in terms of what do we mean by vertical and horizontal, you're saying, Nick, right? So, I think Bill, summarized it completely succinctly and accurately. I guess I would add, when I think of the horizontal institutional powers of the Constitution, these structural ones that the senator was referencing, I think we have a tendency to think that they are very distinct. But I think in political science and in a lot of the scholarship that we see, the common phraseology that we use to understand that horizontal structure is separate institutions sharing powers. I think that's really important to sort of grasp. And that has all sorts of implementation effects when we think about the institutions themselves of government aren't necessarily entirely distinct, but rather they're overlapping and sharing in sort of collaborative in their Article 1, 2, and 3 design. So that's maybe what I would add a little bit to the horizontal understanding. In this vertical one of federalism, I think it's a very tricky one, and for a lot of the reasons that Bill and the senator mentioned. But when we think about federalism, the Constitution itself creates a sort of dual sovereignty between the national government and the states. But, as we know from a lot of the scholarship, a lot of the ambiguities and silences make it difficult to understand exactly where the boundary lines of that vertical design begins and ends. So that's sort of a short answer for you, Nick.
Building off of what the senator said, essentially this argument that things have become distorted, that if as you described, we essentially have the separation of powers across the three branches, even though there is some overlap, as you mentioned, Michael. And then also sort of the vertical, there are things that the federal government can do, things that states do, and then things that local governments do. Setting aside for a moment sort of the textbook answer, if you will, of, well, here's how things are supposed to work in the ideal manifestation of the system, would you agree that some things have been distorted, that either some government branches are maybe not performing their constitutional function the way they should, or some levels of government are not performing the way they should in order for the system to be as healthy as it could? So do you see some areas where, well, the system in concept might be good, but there are some areas where in practice it's probably not working quite the way it's supposed to?
Sure, I think the short answer is yes. I absolutely think that. And as someone who researches and teaches on mostly judicial institutions, I think about it from the judicial side of things. So in one area where I think we've seen some of these inefficiencies or some of these deficiencies that you and the senator are highlighting for us, Nick, is, in an age of, extraordinary polarization, and congressional delegation and abdication in the way that Senator Lee is talking about, I think we see ourselves become more reliant on courts, especially the Supreme Court, right? And we can see that, for example, in the rise in ubiquity of state attorneys general litigating at the federal level to kind of instantiate national change and national policy in the wake of a polarized Congress, to Senator Lee's point, that just doesn't pass as many laws as it used to. And so that's dangerous, I think, in a lot of ways for democracy. When you have judicial institutions being asked to play a more policy-making role that I think was never really the intention. Does that answer your question, Nick?
Bill, anything to add?
No, I think that's right. It's kind of interesting because the senator brought up the statement that Congress is the most dangerous branch, but of course, famously, the Supreme Court is called the least dangerous branch, and that's it's not clear that that's the case, or that people feel that that's the case. And one of the things that's sort of, I don't know if this is getting into the weeds a little bit, but one of the challenges I think the court has is if it doesn't stick, if it responds to pressure and kind of veers out of its lane in any way, we lose an important check. And even though it was intended to be the least dangerous branch in the sense that it's not going to be initiating actions, it's going to be responding to the people through the ratification of the Constitution or Congress through making laws. There is no check anymore, and that's an element of that separation of powers that we could miss, or we could miss out on, right, as a result.
I want to let's drill down on that a little bit because I want to see if there's a way to draw more of a solid line between what the senator was saying about Congress essentially delegating away its authority. And in that instance, he was focusing mostly on Congress, essentially giving authority to the executive branch, to administrative agencies. But my understanding is that it's not so much, with respect to the court, it's not so much that the Congress is explicitly delegating things to the court, to the judicial branch in law, as kind of a delegation by omission. And so I want to know, get both of your thoughts on how much of the controversy around the U.S. Supreme Court, where we have all these high-profile cases, just this last June, there's of course a lot of news coverage about various cases that get a lot of attention and drive a lot of debate, and it becomes a big national story each time one of those big cases comes down from the court. So how much of that controversy and criticism and attention on the court and the way they rule, how much of that would you blame essentially Congress or perhaps even state legislatures not doing the really tough work of policymaking versus other factors that are also elevating that sort of contentiousness around the court?
Sure. How much would we attribute that to sort of this abdication you're saying, Nick? That's a great question. I think it's hard to put sort of an exact figure, percentage. I would say a fair amount. I think when we have legislative bodies that are not enacting things that maybe a majority wants to see done, whatever that may be, it's only natural to revert to other avenues to accomplish those goals. And I think the judicial branch in the United States has become that avenue, I suppose, for a lot of controversial, thorny policy topics that really can't get a lot of traction at the state and federal levels. And by virtue of federal judicial institutions having a nationwide impact, they've proven a useful ground, I think, to accomplish some of those goals for both progressive and conservative ideas and policy agendas. And I think a lot of the silences in Congress and other legislatures contribute to that a fair amount, I'd say. Bill, I don't know if you disagree or...
No, I think that's right. One thought is that there is an example that we've written about at Sutherland sometimes and relates to religious freedom, that there's so many cases decided by the U.S. Supreme Court on religious freedom issues. And a lot of that, I think, is because the states aren't trying to avoid creating conflicts for some of their citizens. Sometimes that's because they're not familiar with the religious practices of smaller religious groups, and so they do things that are unintentionally creating a conflict for someone. But sometimes I think they don't even care that they're potentially creating a conflict. And so the court becomes the forum for having all the, and then of course, I think it tends to, my mind just kind of went blank, but it becomes iterative in that well, we know now that the court is the place to go to hear religious freedom conflicts, and so people continue to go there, where it would be probably better to go to your state legislator and say, oh, maybe you don't understand, but when you ask me to do this, that's at odds with my conscience, and could you make an accommodation? And if the legislature is responsive to that. But so much of national politics seems to me is symbolic. You're almost fighting over symbolic issues. So all the practical concerns often have to be handled by others that can't avoid that. The Supreme Court, pardon me, the third try, I'll get it right. The Supreme Court is not supposed to be the court of, sort of the first resort to get your conflicts resolved, but it becomes that in many cases. I have some other thoughts maybe related to the interplay between the executive branch agencies but maybe I'll hear your questions and see if I can fit that in.
Well, I'm glad you mentioned religious freedom because I was going to mention it if you hadn't. But maybe another issue that especially would have resonance here at a university campus, the issue of student loan forgiveness. And that was another one of the high-profile cases that came out this last June where the court essentially struck down the Biden administration plan. And so I want to bring that issue up in the context of for people, whether it's students or just American citizens or especially the media, the press, that were watching that issue and then reporting on it or discussing it after it came out. It seems that for that issue, as well as many issues that come out in terms of rulings from the U.S. Supreme Court, are usually discussed in the context of, well, was their decision good or bad through the policy lens? Did this help or harm people in a way that voters might like or dislike? And I want to bring that up in the context of this conversation about the proper role of government, in this case, the proper role of the court, to essentially ask if we look at the court and say, well, I don't like their ruling on student loan forgiveness because I think student loans should be forgiven. Is that just simply the wrong framing? Is that the wrong way to think about the role of the U.S. Supreme Court?
Take a look at this one.
Well,
I have some thoughts too.
I think it is the wrong way. I'll say this. If you look at what the court is doing, they're often dealing with, I think they're sensitive to the fact that they're being asked to resolve debates that are really policy debates. And if you actually read the opinions in that particular decision, there's a lot of focus on the idea of standing, whether or not the person bringing the lawsuit has the authority under the Constitution to bring that lawsuit. But you don't pick that up in any of the discussion, which seems to be the nasty Supreme Court has made it harder for people to pay off their loans. And that in one sense, that's understandable. We have to understand these opinions, and I don't necessarily understand all of the doctrine of standing from the Supreme Court. So it's not surprising we would try and make it a little more kind of understandable to us. But I think that's a very negative result. And of course, the litigants can create this problem too by bringing lawsuits in the Supreme Court, that really are policy disputes. Well, either way, I have so many thoughts related to that, but I think that's right. And one thing that makes me think of as well is Senator Lee pointed out how Congress, may be a little bit less nasty in their interactions with each other than we sometimes pick up. The same thing is true in the Supreme Court. If you look at the number of Supreme Court decisions, many of those decisions are unanimous decisions. The justices can come to conclusion. But when we focus only on the sort of the high-profile things, and when we look in a kind of results-oriented way at what the court is doing, then we highlight differences that may distort what's actually happening, I think, in the court and the way it does its business.
Just to refresh my memory, Nick, you're saying, is that the right way to kind of think about
right, essentially
these court decisions?
Looking to the court's decisions and evaluating whether they are good or bad decisions based on whether the policy outcome is favorable. Is that understandable? Is it the wrong framing? Is there a better framing?
I think it's understandable given the age in which we live, but I completely agree with Bill that we really, I don't think it's desirable that we do that. And in recent political science literature over the last maybe 8 years, in continuing as recent as this year, recent innovative research really buttresses that point here, right? So what we see there is that policy disagreement with the Supreme Court's opinion really drives the perception of the legitimacy that you as an individual have of the court as an institution. Right, and not only just policy disagreement, the mechanism there is that policy disagreement with the SCOTUS opinion leads to believing that the court is political, and then believing that the court is political leads you to believe that it's illegitimate in some ways, because we sort of paradoxically see the court as guided by, just principles of neutrality and impartiality and objectivity that we think is associated with strong judicial institutions and strong liberal democratic nation states. But at the same time, we as a public also know, especially at the highest level here, that the court is partisan, at least to a certain extent. And when we're in this age of polarization and partisanship in our minds, in reality here, this sort of policy disagreement in that paradox of balancing the neutrality and the partisan nature of the court really comes strongly into play and affects our perception of the legitimacy of the institution. Now, historically, I think we have always had, the public has always had a sort of what political science calls a kind of reservoir of goodwill and trust for especially the Supreme Court. That's why when Bush v. Gore was decided, half of the country disagreed with it, but we didn't crumble as a nation state, right? And SCOTUS maintained its sort of respect and veneration among the public. But I think over these last 2 decades and a half almost, as we become more likely to interpret legitimacy through policy disagreements and partisan disagreements, we've seen the court, especially the Supreme Court, come down in its public approval. And it remains to be seen what that really means for the rule of law, I think. But I do agree with you, Nick, that it is certainly not the preferred way to determine whether an institution is legitimate or not, whether or not it just simply follows your own policy beliefs.
So can we give a definition or a framework for folks to essentially measure the court's legitimacy by what you would say would be the appropriate standard? So essentially, even to put it simply, if you were to say that, well, the U.S. Supreme Court is legitimate when it does blank, give the folks in the room and watching online sort of a rubric by which they can evaluate the court. If they're out there saying, okay, you're telling me if I think they're wrong on the policy issue, that's not the right way to determine whether or not I think the court is legitimate. What is the right way to measure how the court is doing as an institution, and how can I as a voter apply that to how I form my opinions when a Supreme Court decision comes out?
That's such a hard question. It's a good question. Let me try and start.
Sure, okay. I have a couple thoughts, but yeah.
I think, well, go ahead then. If you go ahead, and then
I'll just say briefly, that is a really difficult question. I think at least one way to think of the Supreme Court, what's a lens through which we can sort of evaluate it, maybe on more appropriate grounds than whether or not they're issuing decisions with which we agree. I think, a Supreme Court, an apex court, I think, needs to be decisive, and it needs to settle disputes among lower courts. It needs to be decisive and consistent. That's hard to say how to figure that out. I mean, you have to sort of be in the weeds of knowing sort of where are these sort of lower level splits, where are these disagreements, but we are in an age now with the Supreme Court having so much discretion over its docket that there are geographical disparities in disputes that are not settled, I think. And so that's sort of a macro level, Nick, rather than necessarily the individual level. But I think a strong apex court in a liberal democracy will attempt to decisively settle disputes among lower level courts and give those courts good guidance to apply that precedent and thus be consistent, apply that precedent to similar disputes that arise in the future. That's a short answer, Bill.
I think that's great. Yeah. And I think philosophically that fits well with our idea of the rule of law, that there's some kind of consistency and I don't want to say comprehensiveness, but I mean like the ability to comprehend what the law is. And that's easier when the court is clear about those things. I would add maybe just that it strikes me that if you were to put together like a help wanted, for a Supreme Court justice, you'd want to warn them that if they really like policymaking, they want to make a difference in the United States, this isn't the job for them. They should find something else, because they're supposed to be, and I think this is part of what was meant when in the Federalist Papers where it describes them as being the least dangerous branch. They're not supposed to be initiating things in the way that the other branches are. Probably really Congress is supposed to. They're responding to things Congress has already done, or that the people of the United States have done through ratifying the Constitution and its amendments. And so they should feel tethered to, in my opinion, the actual text of these provisions. Now, of course, that's not always easy, and sometimes, as we pointed out, and others have pointed out, Congress can be broad in what they say. But there needs to be, I think, a purchase in an actual written document that they, or something like that, including in previous court decisions that they refer to. I think it's important that in our system the court issues written opinions, so that at least theoretically you can look at them and say, oh yeah, that reasoning makes good sense to me. I think that's right, or at least I can understand where the court's coming from and what they're citing to. It's a mania in law school about citations, you know, and you have to cite constantly. I don't know if you read a lot of, sure. Unfortunately, it makes the thing so long and cumbersome, but it's a valuable discipline in one sense, because you don't want the court to just sort of, you know, make up things. They need to always be drawing on existing law that they're supposed to be interpreting in specific circumstances. That's why I think one of the important structural constraints on the Constitution is this idea of standing. Not every issue should be decided by the court, and they should be able to and ought to turn away many things that come to them. They don't always do that, but they should.
So we've got about 10 minutes left. I want to leave some time for audience questions. So if anyone out there who's listening, if something comes to mind, we'll have some folks in the back with a microphone to come over and bring it to you so you can ask your question. So be thinking of that as we move toward wrapping up here in a few minutes. But as you're thinking of questions, I want to ask you to, one of the themes that I think is emerging from this congressional series this year, there are two things that stand out. One is this idea of polarization, and how it's a little different, it's a little worse today than for most of us, perhaps all of us in recent memory. And number two is the idea of nationalization, that it seems that so many of our political or policy fights are being pushed up to the national level. We've talked about, again, these Supreme Court cases as great examples of that, just big national debates. And so I want to ask both of you, applying kind of those two phenomenon to the court itself, as well as the other branches of government, the executive agencies, do we kind of have this 1-2 punch of we're more polarized and more of our fights are at the national level? Is that feeding into this idea of either Congress not wanting to get in the weeds on various issues, so they're pushing things to executive agencies, or these big debates ending up as lawsuits and ending up before the U.S. Supreme Court? What's the role of polarization and nationalization, and is there any way out of it? Is there anything we can do to sort of calm things down and fix some of that distortion of the different levels and branches of government?
I defer to you, Bill.
Well, I forgot to mention this earlier. Your comment about trust, I think, is exactly right. It's very, very important, and I think maybe it's one of our more serious issues as you think about the Supreme Court now. I was looking at a survey related to trust in the court, and I was actually just doing an experiment to see like what I would find if I looked up crisis of legitimacy for the U.S. Supreme Court. And the answer is, there are lots of articles on this. But as I started drilling down into the actual like top line questions that were being asked, the questions seemed to me to kind of invite that, because they ask things like, you know, the Supreme Court reflecting the views of the American people, or things like that. And you think, well, no, that's exactly not what the court's supposed to be doing. And it wasn't surprising then for me to see that the results look like a kind of like a Jaws opening, where the both Republicans and Democrats and independents, so all three, had kind of tracked a similar trajectory in terms of their view of their trust in Congress, with a dramatic divergence where the trust level for Republicans is going to like 70%. I mean, that seems, I mean, I like the Supreme Court, but that's really high, you know. I mean, and the trust level for Democrats going to, I think, in the 20s. That is troubling. The court is not supposed to be withstanding, or not. It's not supposed to be bearing up that kind of playing that kind of role in our system. But part of the problem is that we can complain about things like the consolidation of power at the national level, but the states have a role to play by asking the Supreme Court or the federal government to resolve state-level disputes that they really should take on themselves. So I guess like with my other answers, I've kind of veered here and there, but I think that I think those things are important issues, but the Supreme Court shouldn't be the one to have to try to respond. The court should be able to have some freedom to ignore those kinds of pressures, and I think personally they probably do. But the way we talk about the court, the way we think about what the court does, and the kind of cases we bring to the court are I think, in reinforcing those themes rather than diffusing them, which is where we ought to be trying to go.
I mean, is there sort of a way out, you're saying, of some of this nationalization or polarization? Boy, I think if I had a great answer for that, I probably wouldn't be a professor, in some ways. Not that I don't love what I do, of course. But, I don't know. I think one thing that jumps in my mind is sort of, small d, like democratic tendencies, small d democratic tendencies, right? I'm not sure the public is as polarized as we might think, right? But sometimes we don't know for sure because of the ways our voting systems are designed, our electoral college is designed, right? We have a primary system where we can have candidates win with not even close to a majority, right, and take a national ticket. So I think if there was, perhaps that is a way out of polarization. I mean, that's a massive undertaking, but if we're just speaking theoretically, I think if people were able to voice their opinion and that was more accurately reflected as a democratic majoritarian will, we might see less polarization on a national level. That's just an answer.
Okay, turning to the audience now. What questions do you have? What comes to mind from this discussion that you might want to ask some of our panelists?
We know you're all the truly dedicated.
Yes, of course. Thank you. Wow.
We lost quite a few.
Please.
Hi, thank you for your time, by the way. I'm just wondering if there's any overall themes or times or eras that are more predominant than others where it shows corruption or illegitimacy in reference to presidents electing Supreme Court justices?
That's a good. You've stumped them. That's a good question.
Yeah. I'm not sure necessarily. Corruption is a strong, I think, moniker. I'm not sure I can necessarily think of a time where I would characterize the appointment process as corrupt or corrupted in some sort of way, but it's changed drastically. And we have good answers as to why. I think an important demarcation of how the appointment process has changed, that is, how has it become so polarized and contentious as it is today? There's a multitude of factors, but a couple of them began with the appointment of Justice Hugo Black in the 1930s in shifting that senatorial confirmation process to become more public-facing. It used to not be public. In dovetailing with that a few decades later, the CNN coverage and media coverage more broadly of that appointment process made it much more cantankerous and raucous as it is today. So I don't think actually the president necessarily played much of a role, but more about how that process changed in the Senate's sort of norms and rules surrounding that process, and putting them more in a public-facing light, which lends more to grandstanding and some of the boisterousness we see today. So that's a short answer.
Which probably contributes then to some of the polarization because people are asking questions about policy issues.
Of course.
I think that's right. It's actually, I like the Supreme Court as an institution, and I think that there are very few justices have have been open to a charge of corruption. I mean, I think maybe one justice that was, or nominated justice that was rejected, with that being the ground. There were some early examples of favoritism that would be like Roger Taney, but
of course.
But I think that's right. I agree with that, and I think that we've probably lost something. We've benefited in some ways. There is some, having so much coverage does give us a sense of that we're engaging the process and they play an important role. But I don't know. We may have lost a lot in that process.
Who else? Go ahead and raise your hand. Was there a hand over here? Anyone else have a question on their minds? Otherwise, I have a closing question, but I want to make sure we don't cut anyone off. Wonderful. So as we wrap up, I kind of want to ask both of you to give kind of the elevator answer. So you find yourself in an elevator with the leader of, pick whatever branch of government or level of government that you most wish they would take your advice on their proper role. So whether it's the U.S. Supreme Court, if it's lower federal or state courts, if it's Congress, the executive, on any level, the governor, who do you wish you could be in an elevator with for a few seconds, and if they turn to you and say, hey, I saw that panel, you're really great, what should I do to better execute my duties in this role that I'm serving in whatever branch or level of government? Tell me what to do, and I will do it.
That is a really hard question.
Okay, the hypothetical is if we could just have any of these institutions sort of heed our advice in some sort of way. Boy, wow. God, there's so many answers I'm thinking of. Does one jump in your mind, Bill?
No, not necessarily. I'll say one. This guy can't be held to this as the only one. If I have more thought about it.
Same here.
But I resonated with Senator Lee's comments about the administrative branches. I think that the level of delegation of the administrative branches is a serious problem, and so Congress, you need to make laws, and those laws need to be comprehensible to the people who read them. There actually are some ideas for how to make lawmaking more transparent for voters, so they know what was actually voted on in terms of sizes of bills and things like that. That would be probably where I would, at least on first blush, that would be my thought. Did I give you enough time? Maybe I'll think of number two.
I play these hypotheticals all the time with my students. It's so much easier there. Maybe I'll say one that's a little controversial. If I were speaking to someone maybe in Congress, would have to be the institution that would change it, even though the Constitution says it can't be changed. This is a little controversial, but if the Constitution was easier to amend and the threshold of Article 5 was lowered, maybe we could live into some of Senator Lee's intentions here about being more responsive to the people. With the disclaimer and caveat, of course, if we make it too easy to amend, then it doesn't become the document that it's supposed to be in a higher law. But that would facilitate potential positive changes. But I realize that probably most of the audience might disagree with me on that one.
It's still a good answer.
Well, if we can ever arrange for you to end up in an elevator with the leader you want, that'll give you some time to craft some more robust advice. But we want to thank Bill and Michael, both of our panelists today. Let's give them a quick round of applause.
Thank you. Thank you.
And thanks to all of you for joining us for the Sutherland Congressional Series this year. If we can go to the final slide on the screen, we have a QR code that we'd love for each of you to fill out a brief survey. You can just do it on your phones and give us some feedback about this event, about the entire series, any ideas for future events. We always want to continuously refine and improve. So thank you all again, and thanks to the University of Utah and the Hinckley Institute for the wonderful partnership. Thanks very much.